Mic check, 1 2 1 2. Hey.
Good evening, ladies and gentlemen. Good evening. First and foremost, put a 1 in the chat. Put a 1 in the chat if you can hear the sound of my voice. I want to make sure you can hear me tonight. I wasn't planning on doing a live tonight, but because of the breaking news, I had to come on. And as the title says, the blogger lady got caught finessing the bankruptcy court and Cardi B. But before we get into some things, ladies and gentlemen, I want to do a quick making sure everyone can hear me. Okay, good. Okay. Now, guys, you know I had fell back on reporting on anything Tasha K. I fell back, and I'll tell you why I fell back. Because it was my belief that they were working things out. It was my belief that they were working things out. And, you know, everyone was coming to the table and trying to make this thing work. But while Cardi was trying to show some grace to Tasha K and the hubby was on their finesse game. And I'm going to give it to Tasha K. She got an interesting finesse game. She has an interesting finesse game. I'm like, okay, she's doing shows. From what I'm told, her shows are being sold out. She says she stepped into the comedy realm, which yielded her more opportunity to make more money to get this little small bill resolved. Well, not so small. Bill nevertheless. But before we get into that, I want to talk about another breaking story that came through my timeline earlier today, and that is that one of the YSL defendants, acquitted YSL defendants, has filed, along with another Fulton County detainee, filed a class action lawsuit against the sheriff of Fulton County, Sheriff Labatt. And in that lawsuit, they're essentially alleging the conditions of the jail. And in the lawsuit, they point out the death of an inmate, as well as the bed bugs that have been shown through news reporting as it took over the body of another detainee. And I want to shout out Thugger Daily for bringing this story to the forefront. And yeah, I just wanted to post that up there, but I wanted to shout out Thugger Daily for doing this. I want to bring that up there. And it's a federal lawsuit. And that lawsuit, it's a courageous step by Mr. Shannon Jackson, because he's right now in the belly of the beast. He's in the Fulton County jail trying to get out. And he has a hearing next week. So he's in the Fulton County jail where he was stabbed at as well. He was stabbed. And now he, along with another detainee, has filed a federal lawsuit. The sheriff was asked for a comment earlier today, but he said he hadn't yet to receive the lawsuit. And I'm like, okay, you have a computer as well, like we all do. You didn't know about the lawsuit, but you got to be formally served. I get that. So with that, It's going to be an interesting ride for Mr. Shannon Jackson, and I think he will hopefully prevail in this fight to get out of that county jail. At this point, I hate to say, but he's in a very peculiar situation because he was found not guilty of all the top counts. He's being held because of allegations of smuggling some narcotics and having a shank. But if we put things in perspective, there have been a lot of deaths in that jail, and he might be on survival mode if he in fact had a shank. Now, the drugs that were alleged in the complaint, that too hasn't been vetted out, and the prosecution obviously want to get a win by any means necessary. Now he's filed a federal lawsuit exposing the conditions in the jail. He would know best. He's been in that jail for over 2 years. Well, hopefully this case can be resolved with time served. Not the federal case. The federal case, need to keep this foot on their necks. And hopefully the judge presiding over his hearing, Judge Edwards, will see it fit to give him a bond. And there's a bonding company that is attached to the case, and I'm assuming that bonding company will be coming in on the 17th to show the court, hey, we are ready to put a bond up for this guy. So we'll see how that thing plays out. But let's get into some things, everybody. Let's get into some things here. So I was the initial reporter that reported on the bankruptcy case that Tasha K and her husband filed back in 2022, right after the case had ended for the most part, not much longer afterwards. But prior to that, there was a defamation lawsuit, which obviously you guys know how that ended up. Tasha K lost, her husband lost through the company, and one of the things that was told to her at the conclusion of the loss and the verdict, and the Judge William Ray, instructed her and her husband not to move assets, not to do certain things. And he said it, and it's referenced in the lawsuit that I'm gonna bring up in a minute. He said that he wasn't accusing her of planning on doing that, but that he warned her through an admonishment that if she did such a thing, that she would be held to she would have to be brought back to the court for the most part. And I don't know if she thought it was he was making a tongue-in-cheek type statement, but if you know the history of Judge William Ray and his other cases, he takes these matters very seriously. But all that was put on pause once Tasha K filed her bankruptcy, and she filed a Chapter 11. And this Chapter 11 has been going on, and for this is probably going on the second year, I believe. And Cardi, along with her legal team, thought they had a deal in place to give Tasha K an opportunity to make some payments. And what you guys don't know is there was only one payment made. It was only one payment made. And that payment wasn't made by will, it was made by force, meaning Cardi B's lawyers had to go after those assets, a Google check. It was a nice size Google check, about $9K. They went after the Google check. Once that happened, Tasha K filed bankruptcy to put a hold on the asset forfeiture for her property, from her financial or bank accounts, and all that stuff. The bankruptcy stopped that, and they went to Chapter 11 mode. And there was a series of hearings in the bankruptcy court where the husband testified and Tasha K testified. it was the husband who testified first that certain things that was done to protect Tasha K's assets. One of those things that was done was to move the assets. He literally went in court, not court, but he went into this hearing and testified that they intentionally hid assets so Cardi couldn't get what was owed to her. And I think one of the reasons why, I know one of the reasons why he admitted to it is because Cardi's attorneys and the investigators and their team found out that that Tasha K had hid assets in offshore accounts and in domestic accounts. And it was a point in time where the accountant who worked for the Keebies wasn't able to be located. They knocked on doors. They dispatched the investigative team to find the accountant. The accountant was dodging, running. I won't say she was running. She just conveniently wasn't able to be located up until, I don't want to say too much. Let's just say a very seasoned investigator was able to locate the accountant. And as such, the accountant was able to be served and he had to spill the beans as well. With that, Cardi had her lawyers aggressively looking for more assets. They located an offshore account. They located several offshore accounts. And these accounts were established even though the judge in the defamation case instructed her and her attorney and her husband not to do certain things. But when you read this latest filing, which the lawyers for Cardi B want the case dismissed, or they want it converted from a Chapter 11 to a Chapter 7, the result of such thing happen would be that they can go after the assets like they started to, and nothing can be done to stop them from going after assets. Here's the problem. Money is already in offshore accounts. And the fact that it has been moved to offshore accounts, can you guys think about what that effect would have on Tasha K if the judge says in the bankruptcy case, hey, with everything that we've seen, I think the plaintiff has a good grounds for a dismissal. So, and this is my guess how Cardi will likely move. They get a dismissal, or they get a Chapter 7. And when you have a Chapter 7, all her assets, Tasha K's assets, have to be liquidated. But what else will happen is the assets that are not in America will obviously raise concerns for the bankruptcy, not the bankruptcy court, but District Judge William Ray. Because my guess is that once this protection is no longer in existence, then Cardi now has the ability to go back to the other court and say, hey, Yana, we made every effort to try to negotiate a reasonable settlement, even though the initial argument was by Tasha K's attorneys was that she doesn't deserve any protection because of the way the judgment occurred, where you can't discharge that type of money because it was malicious and the way she went after Cardi B. So now we're here. Within the last 2 hours, and I would say around, 8 o'clock, there was a filing. And it was first reported on TMZ. And it essentially spelled out why the case should be dismissed. So with that said, ladies and gentlemen, let's bring up the real tea. Because TMZ reported a synopsis of what is happening. But the devil's in the details of what Cardi is saying really happened. And we're going to pull the document up right now. This is, the case was never, so I thought it was dismissed. It was never dismissed. We kind of assume, and I say we, the people in the background assumed that it was being worked out, Cardi, Tasha K was paying Cardi and everything was everything. But that wasn't the case. And before I bring the documents up, what Cardi B has alleged in her filing was that Tasha K, and through a series of events, was finessing the court in that, or the bankruptcy court, in that they kind of not even insinuated. They said that, yeah, we had a point of resolution. There were two meetings, two filings, of which there were possibly a resolve to this. The last time they had to address whatever issue would it take to resolve this matter, when Tasha K was asked to show us the money, Tasha essentially said, "Oh, wait a minute. Hold on. This was only aspirational. I didn't really think I could pay the money. This was just aspirational." What do you mean aspirational? You guys, Cardi B's lawyer flew from Atlanta to Florida because they thought they had a deal brokered. Cardi has a lawyer in Florida, but the lawyer in Atlanta flew to Florida because they thought they had a deal brokered. So not only is Cardi B spending all this money through her attorneys, but she's also being misled in this whole situation, the lawyers and Cardi. So we're going to look at the lawsuit. We're going to look at this lawsuit because this thing is crazy. It's like, what are they really thinking? I know Cardi said she ain't paying her nothing. We know she said that a long time ago, but we thought she was just talking mess. Well, apparently, she wasn't talking mess. And it's not, it's not funny, but I get it. She feels a certain way. They're saying that the money's been moved. Let's bring this document on. Let's bring this lawsuit up. Very interesting filing today. And I want to go over the docs. We got them. It's right here. We got the docs right here, ladies and gentlemen. So we're gonna go ahead and read this. This is an exclusive, ladies and gentlemen. So Latasha Transrena Hebe. That Transrena, something about that Transrena just grabs me. The Transrena, it grabs me. So Belcalis Melendez Almazar motion to dismiss Chapter 11 bankruptcy case, or in the alternative, convert case to a case under Chapter 7 of the Bankruptcy Code. Belcalis Melendez Almazar. Wait, hold on, ladies and gentlemen. Hold on. I got to send this. Hold on, guys. I got to do this real quick. Because someone wanted to know when I was turning up. Hold on. Hold on a second. I got to drop a link for somebody, guys. I got to drop this link because I promised that I was going to drop this link. Hold on. Okay. I had to drop this link. I was trying to get someone on. And ladies and gentlemen, there's someone's going to be in the background. Someone of notoriety is going to be in the background as we talk about this. So let's just finish doing this. So Belcalis Melendez Almazar, the claimant, by and through undersigned counsel, moves the court pursuant to 11 U.S.C. Section 105A and 11 12B of Title 11 of the United States Code 11 USC 101 at sequence bankruptcy code. This is all legal mumbo jumbo, but I'm gonna read it anyway for those who appreciates taking down the codes. Rule 1017F and 9014 of the Federal Rules of Bankruptcy Procedures for an order dismissing the Chapter 11 bankruptcy case of Latasha Transrena Kebe, the debtor, with prejudice to the filing of a petition under the chapter of the bankruptcy code for a period of 2 years, meaning they don't want her to be able to file for 2 years. Gives them 2 years to go collect. Whatever they haven't gotten in 2 years, they're going to go aggressive. They're going to go aggressive for the first 2 years from the date of the order. Okay, from the date of the order of dismissal, or in the alternative, converting the case to a case under Chapter 7 of the Bankruptcy Code. And what effect would that happen, ladies and gentlemen? The effect of what happened means she has to sell her assets. She has to sell everything. She has to give up everything if it goes to a Chapter 7. In support of hereof, Ms. Almanzar states, preliminary statement, the Bankruptcy Code is designed to provide relief to the honest but unfortunate debtor. However, the debtor in this case is neither honest nor simply unfortunate. Damn. Since both, and we got to scroll this thing down. I got it zoomed in. Got a little vision issue. Before and during this bankruptcy case, exemplify fraudulent intent, bad faith, and an abuse of the bankruptcy process. As detailed below, following her loss in the defamation action and in direct defiance of the federal district judge Georgia court's explicit admonition not to transfer assets or otherwise impede the collectability of the amended defamation judgment, debtor and her husband, Shekna Kebe. Hey, Shekna, what's going on? Orchestrate a month-long scheme to hinder, delay, and defraud Ms. Almanzar's collection efforts. Specifically, debtor and her husband engaged in the following conduct: fraudulent personal asset and income transfers. Debtor transfers certain assets and income streams to her husband and or his business Yellen Entertainment LLC to hinder, delay, and defraud Ms. Almanzar's collection efforts on the amended defamation judgment. B, fraudulent business asset and income transfers. Kebe Studios LLC, Kebe Studios, a business jointly owned by the debtor and her husband at the time of the defamation action, transferred its assets and income streams to Yellen, which operates as a mere continuation of Kebe Studios without any ownership interest held by the debtor. See, here's one of the things you guys probably remember, that Kebe Studios was also adjudged a $500,000 debt in this lawsuit. So not only did they converted the assets of Kebe Studios, they transferred his assets to another company as well. Okay, Kebe Studios without any ownership interest held by the debtor. These transfers were with the express intent to hinder, delay, and defraud Ms. Almanzar's efforts to collect on the amended defamation judgment. This scheme was specifically designed to shield debtors' income and assets derived from Kebe Studios and to circumvent the $500,000, which I just said, judgment against Kebe Studios, outlined in the amended defamation judgment, and C, untruthful and misleading bankruptcy filings / testimony. Debtor filed bankruptcy schedules under the penalty of perjury that omitted and or misrepresented certain of her assets and overall financial condition. Pursuant to 18 USC Section 152, knowingly and fraudulently concealing assets, making false statement, and under penalty of perjury or withholding recorded information related to the property or financial affairs of a debtor is a federal crime subject to fine, imprisonment of up to 5 years or both. So they are pointing out to the court, this is a federal crime. This is what the Cardi's lawyers are pointing out to the judge. This is a federal crime. Here, debtor and her husband repeatedly provided knowingly false testimony under oath regarding the reasons for transferring certain assets to her husband. For example, debtor's transfer of her ownership interest in the residential home located at 398 Dunlevin Manor Walk, Lawrenceville, Georgia, 30043, Georgia's property, to her husband. They also provided knowingly false testimony regarding the existence, ownership, and control of undisclosed partnerships and onshore and offshore trusts, and misrepresented the business and financial relationships by and among debtor, her husband, Kibi Studios, and Yellen. For example, Mr. Kibi testified untruthfully that Yellen is owned 50-50 between him and his brother. Oh, no, not the brother. I didn't even know you had a brother. Lasana Kibi, who resides in Mali, Africa. Oh, man, that money out of here. The brother got the money. And they have no jurisdiction over the brother, by the way. The brother's holding the bag, allegedly. Mr. Kibi further testified neither he nor his brother have ever taken a distribution from Yellen. In fact, well, hold on. First of all, the brother didn't testify to anything. This is what Mr. Shagner is saying, but the brother's sitting somewhere in Africa. So what he said is not what the brother's saying. And we want to point out that because the brothers know he's in Africa. Wow. In fact, Kibi's tax returns clearly reflect Mr. Kibi owns 100% of the interest in Yellen, and Yellen's tax returns also show that Mr. Kibi has in fact received distributions as the 100% owner of Yellen. So that 50-50 ain't flying with nobody, especially not Cardi B. Thus, Mr. Kibi and debtor are either lying to the Internal Revenue Services or to this court as to the true ownership of Yellen. So lying to the IRS is a problem, and lying to the court is a problem. Crucially, it was only after the claimant at significant expense uncovered the concealed trust and partnerships that debtor blatantly amended her schedules and disclosed their existence. In her amended plan, debtor post hoc self-serving justification for this concealment is not only implausible, but also fails to address and does not cure the fraudulent concealment of the trust and partnerships from debtor's schedules or the repealed false testimony denying their existence. So she tried to repeal the statement that she initially made. I was lying then, but I want to tell the truth now. If you believe this, I'm telling the truth now. She tried to repeal herself. She tried to purge herself of the previous lie. Shout out to Judge Glanville and Judge Whitaker, by the way. Notably, debtor spent over $25,000 to establish the offshore trust. So she spent the money to hide the money. She spent $25K to hide a whole lot of money. Because we spent $25,000 to hide money, you had to have a whole lot of money. In my opinion, Debtor's bad faith in filing for bankruptcy is further evidenced by her acknowledgement that she knew prior to filing for bankruptcy that the amended defamation judgment is non-dischargeable. And this is what we knew early on. She could not discharge the money that she owed Cardi B. It is black letter law that a judgment arising from an intentional tort involving willful and malicious injury, such as the amended defamation judgment, it is not dischargeable. So she knew it wasn't dischargeable. She knew from the gate. She knew the day the judge and the jury came back with the verdict. She probably knew when her lawyer, anybody remember Cardi B's lawyer? Why does the lawyer slip my name on my mind right now? Come on, someone type in the comment section what Cardi B's lawyer name was. Someone type in the comment section what was Cardi B's attorney's name was. What was the attorney's name? I know you know attorney name. Drop it in the comment section. I'm gonna look at it, but oh my goodness, we're talking about her original attorney. Why does it slip my mind real quick? Yo, guys, come on, drop the name in here. Okay, anyway, debtor's bad faith in filing for bankruptcy is further evidenced by her acknowledgement that she knew prior to filing for bankruptcy that the amended defamation judgment is non-dischargeable. It is black letter law that a judgment arising from an intentional tort involving willful and malicious injury, such as amended defamation judgment, is not dischargeable, which I read just now. I just read it again. Okay. Let's go here. In bankruptcy, notwithstanding this, both debtor and her husband repeatedly testify under oath that the primary purpose of the bankruptcy filing was to obstruct the claimant's collection efforts. Why would you say that? Why would you tell on yourself? This is what self-snitching looks like, ladies and gentlemen. This is self-snitching. It is self-snitching. She tried to purge herself from the previous lies, but then she snitches on herself to purge herself. How does that work? This was one of the few points of consistent testimony between debtor and Mr. Kebe. Debtor's bad faith with respect to planned negotiations. Additionally, debtor's bad faith is further demonstrated by her and her counsel's conduct during the negotiations over the financial terms of the second amended plan. The court may recall the following representation made by debtor in her motion to continue the confirmation hearing filed on October 30th, 2024. Number 8, the debtor and her largest creditor, Alkalis Molinis Almazar, Cardi B, have reached an acceptable resolution of the matter. However, they continue to work on the specifics to be included in the debtor's yet to be filed amended plan of reorganization, and the parties are concerned that there will not be sufficient notice of the amended plan to all creditors prior to the scheduled confirmation hearing on November 19th, 2024, which had passed. Let me zoom in a little bit. Let me zoom in just a little bit more. Okay. Okay, motion section 8. It has since become evident that debtor intentionally and repeatedly misled Ms. Almazar, the subchapter V trustee, and the court at significant expense to Ms. Almazar. Cardi spent a lot of money. She spent a lot of money to get to this point in this bankruptcy to no avail. It has since become evident that the debtor intentionally and repeatedly misled Ms. Almazar, the subchapter V trustee, and the court at significant expense to Ms. Almazar, following a judicial settlement conference with Judge Hyman on June 14, 2024, and a subsequent meeting at the offices of the Debtors Council on June 24, 2024, attended by debtor, Mr. Kebe, his counsel, Ms. Almazar's counsel, flying in from out of state, the undersigned, and the subsequent trustee. the parties came close to agreeing on the required plan payments through further negotiation was necessary. So they came in on the first time and thought, hey, we got this woman to essentially say, hey, we're gonna work a plan out. So a lawyer flew in from Atlanta. A lawyer, I'm gonna tell you what lawyer it is. She flew in from Atlanta and went to Florida and said, okay, let's get this thing signed, sealed, and delivered. Because she's been on this case for a long time as well. So the Florida attorney's been on this case for a long time. So it didn't go down like that. It didn't go down like that as they hoped. So what happened next, on August 22nd, 2024, debtors' counsel tentatively agreed to Ms. Almazar's proposed monthly payment amounts contingent on debtors' approval. A counter proposal from the debtors' counsel was received and accepted by Ms. Almazar on September 9th, 2024. This agreement was reflected in drafts of the second amended plan circulated by debtors' counsel on and after November 19th, 2024, which included the agreed upon payment schedule. However, on the day the second amended plan was due to be filed, debtor, in bad faith, unilaterally altered the agreed upon monthly payments in the second amended plan that was filed, and further cherry-picked out certain critical protections for creditors that also had been previously agreed between the parties. So what happened? Let's talk about what happened there. You know how you bring a person to the water, and they were about to drink the water, and they said, wait a minute, this water's dirty. So Cardi B's attorney said, hey, this water's dirty. First of all, those protections were in place so she couldn't wiggle out of the agreement. So when they got to the table, she wanted to pull out the protections. So what point is that? Because we don't trust you. Why would we allow you to pull out these protections that we have in place so we can ensure that we're getting paid, or Cardi getting paid? So not only did she do that, she changed the payments. So it's not a deal. It was essentially going to be a deal. It didn't play out like that. So now that raised the attendance of Cardi's attorneys. They're about to get the 3-card Monty, throw the cards, the shell game. They about to get played, and they knew they were about to get played. So this is what happened next. Debtors' true intentions were revealed when debtors' counsel informed the undersigned that the plan payments terms were merely aspirational. What? What do you mean aspirational? And that no formal agreement had ever been finalized. So you think Cardi's attorney that flew in from Atlanta was flying in on an aspirational plan or a solid plan? That makes no sense. Who does that? So debtor's position is not only demonstrably false, but also puzzling for two reasons. One, the total amount to be distributed in the plan payment schedule remains identified to the total amount set forth in the earlier drafts that incorporated the agreed upon payment schedule. And two, while payments to the unsecured creditors are reduced in the first year, they are consistent with the agreed terms in years 2 and 3 and increased in the years 4 and 5, when the projection are most speculative and unsupported by historical evidence. Given these facts, it is difficult to understand how debtor can now disavow the agreed plan payment schedule as merely aspirational. If the schedule was aspiration before, remains so now, especially since the feasibility of the plan still hinges on several speculative factors, including point one, the Yellen contribution, total roughly 3/4 of the funds available for plan payments, assumptions that debtor will be able to increase her ticket prices over time, and the production of additional content by debtor. So they were talking about the tickets when she's having these shows. She's going to raise her prices over time, supply and demand. The bigger she becomes as a comedian, the more she can charge for ticket sales. So that was one of the things they factored into the plan. And Cardi was amenable to that if there was a base plan in place. She would be able to scale up to get more money. If Tasha made more money and put out more content on social media. So this was a plan that they thought they can effectuate with these agreements. Ms. Almazar was prepared to accept the risk of debtors defaulting under the agreed upon plan payment schedule only on the condition that the safeguards or guardrails she proposed were fully incorporated into the plan. So Cardi sensed that there may be a possibility that she defaults. So this is why Cardi wanted these guardrails in place. But when they got to the meeting, Tasha wanted to remove the guardrails. And when someone moving guardrails, that should tell you something. They're not intent on honoring the plan in the first place. That's what I can deduct from that. Especially is that if those guardrails are put there because of a high concern of not being paid. Then you go to the meeting and say, hey, well, let's just move those guardrails out the way. Let's get them out the way and let's move forward with the plan. But before we move forward with the plan, let's bring those numbers down a little further. But there was no safety net for Cardi B to be able to move forward with that plan. And Tasha knew that. She had to know that. She had to know that. Ms. Almazar reasonably believed that this was the case, as the guardrail provisions appeared in successive drafts of the second amended plan. However, the filed version of the second amended plan reveals that many of these critical protections were selectively removed without the knowledge, consent, or agreement of Ms. Almazar. So they get the document. It was a draft. It was probably a word. They probably just say, hey, let's get that out of there. Let's get that out of here. Let's get that out of here. Let's get that out of here. This is why when I send agreements, I send a PDF form. I'm not sending you a Word document. I'm going to send you a PDF form. And then we get on the phone, and then we'll talk about it, and we can make those changes on the phone. And you'll send it back to me. We'll address, we redline what we don't want. We'll highlight what we want to fix, and then we'll move forward. What she did was, through her counsel, remove the guardrails that no one agreed to. Cardi didn't agree to it. So that already taints the deal already. It already tells me that we don't have a deal because part of the deal is having guardrails in place. This demonstrates the debtor had been engaging in bad faith negotiations, misleading Ms. Almazar throughout the process in tremendous temporal and financial expense. So you not only are you reneging on the deal, you wasted my time and my resources. And this is what Cardi's saying. You wasted my time with this bogus representation that we had a resolution. Because you couldn't have had a resolution if you're now pulling out things out the agreement without asking me can we pull this out first? So now you're wasting my time, my lawyer, you're wasting my resources, and my lawyer had to fly in. Finally, as will be detailed in a separate objection, in addition to debtors being unable to meet her burden to satisfy the good faith requirement of 11 USC section 1129A for plan confirmation. The second amended plan is facially unconfirmable. It is highly speculative, misrepresents debtors' income and expenses, and perpetuates the long-term fraudulent scheme to shield the debtor's assets and income from creditors, particularly Ms. Almazar. In light of the totality of the circumstance, Ms. Almazar respectfully requests the court find debtor's petition was filed in bad faith and enter an order dismissing the bankruptcy case with prejudice, imposing a 2-year bar on refiling under any section of the bankruptcy code. And I'm not going to read the rest of the document. That is the crux of what Cardi has alleged and what she wants a court to address. This is a 56-page document. It's a lot more there, but we're not going to do that tonight. But we want to point out what Cardi has alleged in her filing, that she's basically been how did Lil Woody say? She's been spinning. Tasha K's been spinning Cardi, spinning her. And Cardi's saying enough is enough. We now want to turn it up. We don't got time to play with these fake negotiations, fake plans, when your intention was never even there. Crazy, isn't it? Crazy. So Cardi's attorney is Lisa. She's represented by Lisa Moore, Lisa Moore's husband, who's a part of the firm. She has a New York attorney. Drew Finley is not a part of this. Drew Finley handles Cardi criminal, whatever she has as it relates to. He's a criminal defense attorney. But he has handled a few civil cases as well. But Lisa Moore is lead counsel in this. Shout out to Lisa for putting this 56-page, and her husband and the whole team. This is a very detailed lawsuit. I think put a 1 in the chat if you guys want me to read some more of this lawsuit, because it's 56 pages. If you've heard enough, put a 2 in there. If you want to hear some more of this tea, there's a lot of tea here. Put a 1 in the chat. Now I'll read a little more. Let's see here. So I get some 1s. I got 2 2s. I got some 1s. Let's see here. Let's see here. I'm watching. It gets better, ladies and gentlemen. It gets better. Okay, it looks like you guys want me to read a little more. Okay, hold on. I'm going to read a little more. I'll read a few more pages. Here we go. Here we go. I'm just trying to zoom it in a little bit, ladies and gentlemen. Trying to zoom it in a little bit. Boom, 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 boom. Here we go. Boom, boom. Okay. Jurisdiction and venue. This court has jurisdiction over this core matter pursuant to 28 USC section 157B, 2A, L, and O, and 1334. Venue is proper pursuant to 28 USC section 1408 and 1409. 2. Statutory predicates for the motion are 11 USC section 105A and 1112B. Defamation action and judgment for claimant. As a result of the debtor's malicious and intentional campaign to damage and destroy Ms. Almazar's reputation among her fans and consuming public, not to mentioned debtors' efforts to monetize the defamation for greed and spite. On March 21st, 2019, Ms. Almazar commenced an action in the district court for the Northern District of Georgia against Debtor and Kibi Studios, among others. In the case styled, Belcalis Malanis Almazar versus Latasha Transrena Kibi et al. Case number, I ain't gonna go over the case number. You guys know what the case number is. It's here. On January 10th, 2020, the Georgia District Court commenced a jury trial lasting multiple weeks, in which the jury ultimately found debtor and co-defendant Kibi Studios liable to Ms. Almazar for defamation, invasion of privacy, false light, and intentional infliction of emotional distress, and further found debtor to be jointly and severally liable for damages with co-defendant Kibi Studios. As a result of the jury verdict, on February 17, 2022, the Georgia District Court entered its judgment, the original defamation judgment, defamation action, EFC, blah, 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 in favor of Ms. Almazar and against debtor Tasha K and Kibi Studios. On July 19, 2022, the District Court for the Northern District of Georgia entered its amended defamation judgment, defamation action, pursuant to which the District Court awarded $1,025,000 for pain and suffering and or reputational injury and for medical expenses against defendant and Kibi Studios jointly and severally. B, $1 million in punitive damages against defamation and $500,000 against Kibi Studios. And C, $1,338,753.47 for litigation expenses against both defendants. That's a lot of lawyer fee money, and Cardi paid that already. 7, on August 22nd, 2022, Ms. Almazar initiated garnishment proceedings in Gwinnett County, Georgia, case blah, 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 blah. On number 8, on March 21st, 2023, the 11th Circuit Court of Appeals affirmed the Georgia's District Court's amended defamation judgment, defamation action, EFC number 258. Number 9, on April 4th, 2023, $304.81 was garnished from Google LLC, representing debtors' income for the YouTube channel. An additional $1,083.22 was garnished from Chase Bank. However, the garnished income was not distributed to Ms. Almazar and remains in the trust account of Ms. Almazar's state court counsel, Daniel T. Silas. So Cardi didn't even get that little change. You know, that's gas money for Cardi, but she didn't get it. She didn't get none of that money that they procured from garnishment touched Cardi's hands or her account. On May 25th, 2023, in furtherance of her efforts to hinder, delay, and defraud Ms. Almazar's collection efforts, debtor filed the above-captioned bankruptcy, even though she knew at the time that the amended defamation judgment was non-dischargeable. Worse, he emphasized worse. Oh my goodness. Worse, debtor continues to live her life in luxury. For example, in the post-petition period, the debtor and her husband moved into a more expensive apartment compared to their pre-petition residence with a monthly rent of approximately $7,000. $7,000. Additionally, that's a lot of change. Additionally, the debtor's social media accounts showcase her wearing what appears to be high-end clothing, handbags, and jewelry. So they were pocket watching. Cardi's attorneys were pocket watching, looking at all the luxury that Tasha K has now procured. Plainly stated, the debtor continues to evade accountability for her willful and malicious actions against Ms. Almazar, maintaining a luxurious lifestyle without making any payments towards the amended defamation judgment. In contrast, Ms. Almazar has been compelled to incur substantial expense to enforce the judgment, safeguard her rights as a creditor, and uncover the debtor and her husband's concealed assets and false testimony given under oath. 3-card Monty, ladies. Watch the card. 3-card Monty. Debtor and her husband hinder, delay, and defraud claimants' collection efforts. On January 25th, 2022, after reading the jury verdict at the conclusion of the Georgia defamation action, the federal district court admonished debtor and her husband not to transfer their assets or otherwise change their financial condition. What does that mean? That means you don't go from $3,400 living expenses for rent to $7,000. They change their living condition upwards. Well, darn. That is what it is. Okay, here we go. Transpired before. Wait, hold on. Did I miss something, guys? Hold on a second. Let me go back. What page was on? Hold on. Hold on a second, guys. Hold on. I done lost my place here. Okay, no, I didn't. Here we go. On January 25th, 2022, after the court, I want to say this to the defendants. This is a very substantial verdict that has been rendered against you, and your ability to satisfy it is independent of the fact that it exists. I would just caution you not knowing what may have been transcribed, what may have dischargeable, that has diverted assets. Wait, hold on a second. What may have dischargeable, that has diverted assets and income to her husband and his companies, ensuring. I'm missing something here, ladies and gentlemen. Okay, I need to finish reading what the judge said. Okay, it's hard to follow here. I'm sorry, guys. What may have, let's see if it's over here. Let's see here. Transpired before today, or what actions you may have taken, but I would caution you about any alterations of your finances or changes to your finances in an attempt to try to make the judgment less collectible than it is. Under Georgia law, efforts to do that can constitute fraud and can subject you to an additional tort claim and or lawsuit, much less an effort that could be brought to in this court to enforce the judgment, as it is to set aside actions that you may engage. And given that both of you at least tangentially are involved in this case, by transferring assets, if that were to happen, and I have no information to suggest that you would do that, but defendants sometimes do, into the names of third parties, could also subject them to also possible tort action in the future. And Judge William Ray said this. He said this in court. I was there. The lead attorney was there. Lily was there. The other blogger lady. Now let me go. I'll be nice. I'm gonna be nice. But Infamous was there. Side note: I invite Infamous to come with me to cover the case. I invited. I said, "Listen, I want you to take some notes. You sit over there, just take notes. Don't act out. Just take notes." Well, we see how that played out. Anyway, so this is what Judge William Ray said to her. He said this. He said, "I'm not saying you're going to do this, but don't do it. I ain't saying you and your husband's going to try to hide your assets, but others have done this in the past, and they have paid a price." That's what Judge William Ray told her, essentially. And I'm paraphrasing, but he warned her not to do this. But the minute she got out of that courtroom, got into that parking lot, and You can see the video on Choke No Joke where I try to ask her a question and the door wasn't opening. And y'all saw that video. Shout out to Choke No Joke. That was a funny video, Choke. You really got me there. You got me. Okay. So, it's so much more. It's so much more. This gets even, you got to imagine, ladies and gentlemen, if we're only on page 11, Cardi is digging in. She's bringing out some things that I never even knew. With that said, put a 1 in the chat if you want me to continue. Put a 2 in the chat and say, nah, we good. We heard enough. We heard enough. Put a 2 in there if you heard enough. Put a 1 in there if you want me to continue, because it gets better. Oh, it get better. When I tell you it get better, D. I hit D. It gets better. Cardi really goes in on this one. I'm gonna tell you something. This one right here, she mad. She mad. She's like, no. You don't waste my time, waste my money, and you gonna play in my face? Okay, we're gonna keep on going. We're gonna keep on for a little while longer. Oh my goodness. And I want to say, ladies and gentlemen, if it appears that I'm struggling, it's not because I can't read, it's because some of the words are smaller, and Uncle's a little vigilant, have a little medical issue going on, but that's besides the point. We're gonna read this. Oh, okay, let's see here. Let me see where we at here. 12. Detta and her husband knowingly disregarded the court's admonition. They spent thousands of dollars hiring multiple asset protection professionals to what? To facilitate the transfer of assets and establishments of both onshore and offshore trusts designed to place their assets beyond the reach of Miss Almazar. They said, no, you're getting too close to the assets. We want to push you back. And we want to hire some assets, asset team to hide the assets. They're literally people that can teach you how to hide your money. They're there. And Tasha and her husband hired them. As detailed further below, Detta and her husband provided false testimony under oath regarding the existence of the partnerships and onshore and offshore trusts and deliberately concealed their existence from parties in interest in this court. In addition, Detta knowingly lied when untruthfully answered no in section 25 of the schedule A and B when answering whether she owned any trust. You'll remember I reported back then that she said she didn't own no trust. You don't know what they're talking about. But as you can see, she tried to purge herself of those lies. It don't matter when you're under oath. It's different when you deal with the feds. You can't just simply say, well, I lied then. That don't fly too well when you take an oath. Don't fly too well. It's perjury. That's what that is. It's best you probably should have said nothing. I'm not giving legal advice. I'm not a lawyer. Shout out to Mel, by the way. The false statement was not corrected until June 14, 2024, an entire year after the petition date, when it was addressed in an amended filing made necessary because Ms. Almazar independently uncovered the existence of the previously undisclosed partnership and onshore and offshore trusts. And they say they reference the schedule. So Cardi was just not going to accept her word that she didn't own any trust. Cardi was already looking for the trust. And she dispatched a team of skillful investigators and forensic accountants to find the trust. Most trusts, you're not supposed to know how to find a trust. But people were talking. They were snitching. People were snitching. They were dropping dimes. They were dropping quarters. For those who are old enough know what dropping a quarter means. It's like back in the day, we had these pay phones. You drop a quarter in there, and you say 911. Anyway, I'm telling my age. Over the course of multiple 2004 examinations, Debta and her husband testified untruthfully numerous times and plainly contradicted each other's testimony. Why is this funny? You guys remember when I was reporting on the case in federal court, I would come outside and say the husband's throwing her under the bus and she's throwing him under the bus. I reported this in the defamation case when they were giving testimony. But it does seem like that pattern has continued in the federal bankruptcy case because each of them contradicted each other until they were confronted with their contradictions. That doesn't, I don't understand that kind of this new kind of finesse to me. Like, why would you throw your husband under the bus, and then why would he throw you under the bus only to come back and have to clean it up? It wasn't really cleaned up, but it does expose that you guys didn't go in with a consistent story. You didn't go in and, it's kind of weird to me that you guys are under oath in both instances. It wasn't that serious when the defamation trial was happening because the lawyers were able to cross-examine each of them. And the lawyers for Cardi was able to extract what the truth was in front of the jury. This is not a criminal, the bankruptcy is not a criminal case yet. So I don't know if they understood the seriousness or significance in being truthful on paper, because this is a clearer paper trail than was testified in the defamation case. So it's kind of, I've never seen a case like this that was so obvious that the intention to defraud was there. It just makes no sense. But again, maybe they have a plausible, I won't say that. I'm not going to do that. Well thought out. Anyway, let's go. With respect to Debta's transferring assets out of her name since 2022 to avoid garnishments, she testified. Now we're going to go into what she actually, this is what Tasha K said. With respect to Debta's transferring assets, okay. She says, question, that's exactly how I meant it. Since you were sued, have you been taking assets out of your name? Ms. Simmons, objection. This is apparently Tasha's attorney. The witness, since 2022, yes. Cardi's Tasha K saying yes. By Mr. Moon, this is Cardi's attorney. Oh, question. Okay. And why have you done that, Ms. Simmons? Objection. The witness, which is Tasha K. To keep my funds from being garnished and not being put out on the street. Okay. So how do you deal with that? Now, most people say that's a plausible answer. I want to protect my family, and I don't want to, I want to protect I don't want to get kicked out anywhere. But then how do you reconcile that with going from $3,400 to a $7,000 a month place? How do you reconcile that? How do you reconcile the fact that the judge, William Ray, and the district judge tells you not to do certain things? He wasn't saying, well, you can probably do it and, I can let it fly. He didn't say that. He warned you. He gave you an admonishment. So the witness, she says in this hearing, this 2004 hearing, that she did it to protect her assets. With respect to the debtor's transfer of the ownership interest in the Georgia property, Mr. Keeby admitted that the transfer was made to avoid garnishment. Again, self-snitching. You snitched on yourself to avoid garnishment, but you transfer assets which went against the judge's order. Why did your wife transfer her interest in the Georgia property to you? Shagna says, answer, I guess to prevent garnishment. You guess? You knew. You're all husband and wife. Y'all didn't talk about this? I don't know. You say you don't know in your answer. You don't know? Number 10 question. Regardless of whether you know about the transfer at the time, there did come a time when you found out that your wife had transferred her interest in the Georgia property to you, correct? Answer, yes. That's shaking to say yes. Mr. Lieberman, same objection. Give me a second. Mr. Moon, who's Cardi's attorney, question. And you didn't do anything to reverse that transfer when you found out, did you? Shaking says, no. Why would I? We tried to do some things. I'm just paraphrasing there. Question. And you didn't do anything to reverse the transfer because you wanted to help her avoid garnishment, didn't you? Then Tasha's lawyer, objection. Calls for legal conclusion. Mr. Moon, you can answer. The witness, yes. With respect to payroll payments for debtor that were being paid into Mr. Keeby's personal bank account to avoid garnishment. This is where it gets kind of crazy, ladies and gentlemen. This is where it gets crazy. Question, why are you making payments to Latasha into this account that's only in your name? To prevent garnishment. Self-snitching. You're self-snitching yourself again. Debtor further testified regarding payments for debtor going to Mr. Keeby's personal bank account. Question, okay, if I were to tell you that your husband testified that payroll payments from Yellen are being paid to you into the Bank of America account with your name off of it to avoid garnishment, would that be a correct statement? So they now confronts Tasha with the husband's statement. Their meetings were separate. Shagna had his meeting, then Tasha had her meeting. So what they did was they used his statement to confront her at a later date at her meeting. So this is how she responds. Mr. Simmons says, her turn to objection. The witness, probably, yeah, that would be a correct statement because I know that checks that he did right because I didn't look. You know, I'm like, huh? So you were being paid from another account, a Yellen account, and he testified that he was doing that to avoid garnishment the way you were being paid. So Cardi's attorney asks, question, okay, and if your husband testified that he stopped making payments to you because you told him to stop so it could avoid being garnished, would that be a correct statement? Ms. Simmons, objection. The witness, that would be partly correct. He said that would be partly correct. This is Tasha talking. With respect to taking her name off of joint bank accounts, Bank of America accounts. Yeah, take my name off of everything. If my name is attached, it's tainted. That's what she told her husband. My name can't be listen, we ain't putting our name on any. My name is not going on anything. And you also took your name off of the Bank of America account, joint Bank of America joint account that you had with your husband, didn't you? I did. Answer, I did. And question, why did you do that? Answer, because it was going to get garnished too after they did the Chase account. So she knew they were on her ass. They were on your ass. They were coming. They were going through the accounts. They just didn't get to the Bank of America account. They had got to the Chase. And you knew they was coming. You knew this. With respect to debtors' funds she was trying to keep from being garnished, debtor testified. Question. So how was he paying for your share of the rents? Mr. Simmons. Ms. Simmons comes out and says, objection again. The witness. Because he was managing my funds that were coming in that I was trying to hold from being garnished. Okay. This is a Bonnie and Clyde type of testimony. Bonnie and Clyde, they working in unison. They are, which I just boggles to the mind. You're self-snitching. You're telling on each other. You implicated him. He's implicating you. Would he be absolved from any criminal liability? Nah, not really. Not really, because you both were in court. You both had the knowledge. District Judge Ray told you these things. And now you're coming to another jurisdiction. You went from Georgia to Florida, and you're both admitting that you've done something wrong. It's not the best outcome, I don't think. Question, Mr. Moon asks, Cardi's attorney asking, and those were the funds that were being held at Yellen Entertainment, correct? Answer, correct. Ms. Keeby testified that the debtor, Mr. Keeby testified that the debtor, Tasha K, directed him to stop making payments to her to avoid garnishment. Question, so did she tell you to stop paying her? Answer, yes. So now he's telling on her. Oh, I don't know. This is question. And that was so you could prevent it from, or she could prevent it from being garnished, correct? Answer, yes. So Shackman says yes. He also goes on to say, Mr. Keeby admitted he was assisting debtor to avoid paying the defamation judgment through garnishment. Question. So you understand your wife was trying to avoid paying my client through garnishments, don't you? Mr. Lieberman, objection, calls for legal conclusion. Mr. Moon, you can answer. The witness, yes. Mr. Moon also asks, and you were helping her to do just that, weren't you? Mr. Lieberman, objection, call for a legal conclusion. Mr. Moon, you were helping her to avoid paying my client, correct? Answer, yes. So they continue on September 15th, 2023 with examining Shackman. Mr. Keeby admitted he was holding money for debtor's business unwind with Tasha K to avoid garnishment. So much more, ladies and gentlemen. There's a lot more there. This is a very, very intense file. And we only at page 16. They should have had this story straight. I agree. The gold expression, they should have had this story straight. I don't know what they thought going in, because your attorney should have advised you, at least gave you an idea on what type of questions would be asked of you. And again, some would argue that they didn't perjure themselves because they told the truth in the examination. Well, no, they didn't tell the truth initially. They came back to clean it up because they understood. I would argue that they were in legal jeopardy, still are in legal jeopardy based on this filing. With that said, ladies and gentlemen, um, what do you guys think? Are you good with, because there's a lot more. We're 40 pages away from a conclusion to this. I don't think I want to do this all tonight. Do you guys get the gist of what's happening here? Do you get the understanding of what Cardi is trying to get accomplished at this point? Sheikh is a U.S. citizen. Well, he's a U.S. citizen. He's been here. He's a U.S. citizen, and he may hold dual citizenship. I saw the question asked by MNPD. So I think we're going to do a part two. We're going to do a part two. Yeah, we're going to do a part two. It's a lot here. Or I could fall back and not do a part two. I don't know. Know what? We're going to do a part two in the membership section. That's what we're going to do. We're going to do part two in the membership section. We're going to keep that to the membership. This is a lot to unpack here, ladies and gentlemen. So if you have a membership, we'll do a part two and we can address what else is being requested by Cardi's attorney. It's a lot. I had to get up early. I wanted just to give you a breakdown of what Cardi's lawyers are trying to seek. I think they're going to be successful. I mean, the fact that Cardi keeps pouring money into this case, she wants a substantial resolution to this. She doesn't want it tomorrow. She wants it now. She wants it now. She wants it now. D asks about the lawsuit. I spoke about the lawsuit earlier in the beginning of the live. You came in late. I spoke about that. We spoke about that. What I also want to talk about, I guess I'll wait till tomorrow. I'll do another. It's another story I want to talk about tomorrow. But tonight, this is about this lawsuit. Let me see if I have any questions I need to read. Stand by. Let's see what I got going on here. Hold on, ladies and gentlemen. Hold on. I don't look at the comments while I'm reading. So for those who have left comments, let's see here. Oh, Cardi's going for her attorney fees, but before you go for your attorney fees, you got to get what you got. You got to first get some of the money that's owed to you. Hey, but you guys got to do this. This is what you got to do. This is what you got to do. You got to do this. You got to do this. Shout out to a little bit of everything. A little bit of everything. I gave you a little bit, but I didn't give you everything tonight. I gave you a little bit, but I didn't give you everything. So yeah, go follow what she said to do. Go follow what she said to do. Follow the channel. Let's get these numbers up here. We need to hit the like button. If you want to watch on YouTube, hit the like button. Class E Beats. I see Class E. Shout out to Class E Beats. I like this. I like his content, ladies and gentlemen. I like his content. Very respectful. He gets to the point. He does a good job. Go ahead and follow Class E Beats. Go follow the homie. And I thought I was seeing doubles today. The video he did. It's kind of funny. I saw a picture of his beard on, Pietro. I said, wait a minute. When was this done? Oh my goodness. Hold on a second, guys. Let's see what we got here. I'm just reading some comments. Oh, I see. Okay. So it's a Cardi old folks too. Yeah, but you want to be able to pay those folks with the money that people owe you. People owe me money. I'm trying to collect from the people that owe me money. So when I listen, it's going into a new year, you want to be able to resolve any financial issues outstanding. But you know, she's spending a lot of money now. This case has become a liability for Cardi. This case has become a liability. It was already a liability, but even more of a liability because she's still paying to fight this case. Resources, time, is a lot. It's definitely a lot, and I get it. You know, Tasha trying to keep all her money. She said, I don't want to pay anything. I work for this, and I need to keep this. I need to keep all my money. I got my family that depend on me. I got expenses. You know, this is not the top of my list of people to settle. I mean, but you got to put a deal in place so people know that you're serious, and that's where the issue is. You're not putting something in place where Cardi can feel that you are serious. You want to remove guardrails that were put in place to guarantee that some money was going to be coming in house. Then you change the amount of money that you want to put forth. Then you increase your lifestyle and disregard what the judges said. So this is going to be a problem because they now want the case dismissed so they can go after your assets. And they're not just stopping at Cardi. They're going after yelling. They're going to, do certain things. They're going to do certain things. Just imagine someone owes you money, and and you go into listen. You go into the car dealership. Cardi goes in the car dealership. Someone owes her money. Tasha comes in there looking to buy a Rolls Royce too. Cardi's looking to buy a Rolls Royce, and Tasha K's in the same dealership about to buy a Rolls Royce. Man, what the heck? What are you doing here? I'm looking for a Rolls Royce. What are you doing here? Um, I'm just looking for a car. But this is a Rolls Royce dealership. What are you doing here? I was looking for the Honda dealership. No. It's just crazy how this the other let me tell you, ladies and gentlemen. Right. So John said sound like it sounds like Grey Goose Funny. Oh man. Well, congratulations to Tasha. She's making a lot of bread. She's making a lot of bread. Those tax returns, the IRS, but Tasha K could have sponsors. They could be people giving it to her. I don't know. I don't know. Well, we'll see. Anyway, ladies and gentlemen, I do appreciate you coming on. We're going to do a part two tomorrow. We're going to do a part two tomorrow. We're going to do a part two. I haven't even read the rest of I have not read the entire document. I actually read the document in real time. I hadn't read it. So there's a lot to unpack. And we're just on page 16. We're on page 16. There's a lot there. And how pissed do you think the judge is going to be that they got to read all this? I don't know if the judge will be pissed, but this is what he does. But we will do a part two. I'll announce it. But I have another story to do, and I have this interview tomorrow. You know what interview I'm talking about. You know which one I'm talking about. With that said, ladies and gentlemen, we're going to end this, and I thank everyone for coming in. Um, I wasn't planning on reporting on this, but this was necessary. I should say, by any means necessary. All right, ladies and gentlemen. With that, you know how we start. We end the way we start. Good night.